Ruskin. How are you?
Hi, Mark. Doing good. Good as can be expected. How about that?
Yeah, I guess recent developments have caused both of us to dip back into the closet for shirts with collars.
It's been an unusual, 5, 6 months? Yes.
All right, well, good. I think we're live now, just so you know, for the record. You're a lawyer, so I'm trying to be all official.
Do we have a court reporter?
Well, we're recording the proceedings, so we have evidence.
Same thing. Okay, good.
Because I just heard the judge asking for evidence in the case, so it's one of the things. I don't want to, get all like, CNN analyst on you, but there are a lot of people that have those kinds of questions. But first,
yeah,
I guess we should just. I wanted to welcome you, David, and Abraham, who's the brains behind the medical cannabis community, and my friend and colleague, Shawnee Williams, who is just part of our gang here at the medical cannabis community and helps us with production. And Shawnee's mom just had some surgery. And so, you know what, a lot of this is important, but that kind of stuff reminds us of what's really important. So Shawnee, you don't even have to unmute yourself, but just know that if you don't want to, but just know that all of us are thinking about you and are reminded, therefore, of what's important in life and sending your mom the best. So, David, where do we start?
Yeah.
We just had like I don't know who John Lowy is. I've never met him. Hopefully, I will sometime. But he had a. And again, I don't know these things. I don't listen into a lot of federal court proceedings, but it almost sounded to me like he had a, I sort of said in my own head, holy shit, he's having a Perry Mason moment.
Yeah.
But actually, you know what? Let's take a step back.
Sure.
Before we start, can you just give us a few words about who you are, your background? You're a friend of mine, glad to have you on, but tell us who you are, your background, your connection to the cannabis world, and really, actually, very importantly, why don't you even start by telling us what your connection to these proceedings are? Sort of, do your clients have skin in the game, or what?
Yeah, sure. So thanks, Mark and Abraham. So yeah, I've been a lawyer for longer than I can count, and before getting into the cannabis industry about 5 years ago, I was a business litigator. And so, in the courtroom, I have done it for many, many years. And so, when I talk to you, Mark, when you call me up with questions, or when clients call me up with questions, they're all real quick questions. Then a half hour later, I love talking about it. So it makes sense for you to call me and ask me to speak on what's going on here, because there's a lot of people with a lot of interest, direct interest. As you mentioned, I have clients myself. Being in the cannabis industry, I have helped clients with their applications, this round included. And I will say, I want to be clear, I do not represent any of the plaintiffs in this case that we're going to be talking about today, which is this South Shore Restore case versus the FPR in federal court. It was the first case that was filed.
Hey, David, I don't mean to stop you. It sounds like your mic is cutting in and out.
Oh, I'm sorry.
Let's see. It's better now.
Great. I'll get close. Sorry about the close up on my face, but I was saying that this lawsuit that we're talking about, and probably a lot of folks were listening into today, the first one that was filed after the notice came out last Thursday afternoon, with the 21 lottery selections. So it gives it some importance. It's the first one. It's in federal court. You may have heard, people may know that there was a first amended complaint filed earlier this week that added more plaintiffs more applicants that aren't on that list of 21 into the lawsuit. So it's gained momentum. And of course, they're seeking injunctive relief, which means they want the judge to rule and first and foremost, stop the lottery process from happening before the toothpaste is squeezed out of the tube, and get some relief, at least some initial relief, injunctive relief initially, before things are squared away. So you asked me a bunch of questions, Mark. I hope I answered most of them, but yeah, so I have some folks that I did help out and I'm currently helping out. And some of them, usually the question is, well, what do we do now? Right? We're in the same position we're hearing about. We didn't receive 252 points. We received some dings here and there. Maybe we got some of them got deficiency notices, some of them didn't. What do we do? Do we file suit? What are our options? Do we call up John Lovey, who's the plaintiff's lawyer in this case? So, that's one of the things I think we'll talk about today is what are the options? And also, just to be clear, this isn't the only lawsuit. There was another lawsuit filed in state court. The one we're talking about today is in federal court, the Northern District of Illinois. There was another lawsuit filed earlier this week in state court, the Circuit Court of County. I haven't gone back to really dig in yet in the last couple of days, but there may have been other lawsuits filed both in the Circuit Court of County. There's also an option to file in the Circuit Court of Sangamon County in Springfield. So there may be lawsuits filed there. So I'll stop there and see if you have any other questions.
Well,
or what your other questions are. For sure, there's a lot of questions.
Well, actually, I think you touched on the main question. A lot of the people who are interested in this stuff, that's their question right now. All right. So I was an applicant, or I know an applicant. People are trying to figure out, I think, there are really two main questions. We might as well start there and then sort of do the other stuff. But what should people be doing now? So let's say you're an applicant who was notified you didn't win. And let's say you haven't even gotten your score yet. And you're trying to figure out what to do. Number one, about your score. Number two, about your legal options. And do you sue now or do you wait? And if you wait, how long are you waiting? Until what are you waiting? And then if you are suing, what are the differences between joining a lawsuit and suing separately? So again, I'll probably, this is more of a conversation. I don't want to rapid fire questions, but like I've had those questions Facebook and LinkedIn to me like 6 times in the last 24 hours.
Yeah, and you and me both. I mean, there's obviously we know the volume. There are a lot of applicants out there, and sadly, there's a lot of applicants that aren't on the lottery list. So there's a lot of questions. And let me first say, Mark, I didn't already say it. I can't really give specific legal advice to people that are listening in because I don't know your situation. Everyone's a little bit different. Right, everybody has different fact scenarios, might have different arguments, and so I'm going to give you some general answers. But the first answer, first and foremost, is if you think you want to contest the results, then you should contact a lawyer, because the first thing a lawyer should do is figure out what your specific issues are. And then from there, decide what the best approach is. And I'll tell you what the options are, because they are relatively limited. Right now, you can, and by the way, I want to address something you also asked. If you didn't get your score yet, put in a request for it. Certainly, and if you have, what we're hearing is, and I don't know how accurate this is, some folks have put in a request for the score and have not received it. I've heard recently that the IDFPR has stopped issuing scores, which makes no sense to me based on what's going on, but that may be true. But do keep following up. It's important to get at least that initial scorecard.
David,
You heard,
can I just jump in for a
sure.
second? When you say ask for your score or get your score, what is it that you're specifically suggesting people do? Do they email somewhere? What are they
Yes.
doing?
Yes, you email, and you can go on to, if I'm not mistaken, it's either the IDFPR cannabis page, or oh, you know what? It's if you, when you receive the email from IDFPR saying you weren't in the lottery process, I believe there's a link there. But it's an email to the IDFPR. You do not have to issue a formal FOIA request. In fact, I think if you actually send it to the IDFPR FOIA site, they will kick it back to you and say you don't need to do it.
And I just wanted to note that we got, running comments going in chat here, and our friend Tom Howard provided some information on the email or whatever to follow up. So thanks for that.
Yeah.
And David, like, do they have to give it to you? I mean, what's to stop them from not giving it to you? Because that's what I think is happening now.
Well, they hold the cards, and so do they have to give it to you? No. But ultimately, you're entitled to the score, and you will get
an application fee of thousands of dollars.
Of course. Now, I will say to you, most of what is being argued in this case and the other cases as well, is based on the lack of transparency, right? And so, by not even providing applicants with their scores, it's just that would be baffling to me. But equally as problematic is what you'll probably find when you request your score is you get this scorecard that essentially gives you the points for every exhibit and your total points, but that's it. So don't expect a lot of information. And if you were listening on the hearing this morning, you probably heard that part of the argument is we don't even have information. We have these property rights in the licenses and the application for the licenses, and yet we're not even being told why we didn't score a perfect score or why we were dinged in certain exhibits. Or even you heard some of the allegations in the complaint you heard today, why we scored one score in a particular region, but then received for the same exhibit a different score in a different region. That's part of the issue. So let's back it up. Definitely find out your score. Get that scorecard from the IDFPR. You want to see that. And that'll help make decisions in terms of options for next steps. And that's what the other question you would ask, Mark, is, well, so what are the options? After you look at your score and talk to your lawyer and decide whether or not you actually want to pursue this, your options are, in no particular order, you can certainly call up the plaintiff's lawyer in the case that is in federal court, the South Shore Restore case that many of us were listening to this morning. You even heard him say he's been receiving calls. He has another, I don't know what he said, 50 or so that are seeking to join in, or at least talk to him about joining in to that case. That is one option. Another option is to file your own lawsuit. And filing your own lawsuit can be done in federal court, like this case is. It can be filed in a state court, Circuit Court of Cook County or Circuit Court of Sangamon County. And another option is to wait and see what happens in the next, what's it going to be, 6 days or so, and what this Judge Alonso ends up doing on this particular hearing. We're expecting to get a ruling next Thursday, I believe. I don't know if I should say we're expecting to get a ruling because it's very possible there's going to be hours of evidence presented and then a ruling may come shortly thereafter. But certainly it is one option to wait and see what the judge how the judge rules. And when I say that, if the judge actually grants injunctive relief, and injunctive relief is just, let me back up a little bit.
David, let me just interrupt you. It actually sounded like your microphone started jumping when you moved forward. So maybe if you try to sit back a little bit, that'll also save us from looking at your face so much. But
yeah,
let's try it and see what happens.
Sorry about the mic issues. If you have an issue, flag me down and let me know.
Well, well, I'm not going to complain about your face, but no, it sounds much better when you're sort of sitting back like that.
Good.
Thank you.
So I wanted to explain just real briefly injunctive relief. What they're asking for is to stop the lottery process. So that is, they want the judge to prohibit, injunctive relief is either prohibiting action from being taken or compelling some action to be taken. Are you still having trouble hearing me? All good? Now you're
Mark's on mute, but yes, it's a little
we
choppy.
can hear you. Keep going.
Okay. So in this particular instance, what the plaintiffs want is injunctive relief to stop the lottery process. Right? You can hear me now? Everything okay? Okay. To stop the lottery process so that the issues that have been alleged in this complaint that we all have heard about, and we all know about, the due process issues, deficiency notice issues, a lack of a administrative challenge on the law, right? These issues need to be determined according to this complaint before the lottery takes place. And so the injunctive relief that they're seeking is to stop the lottery, or at least delay it for sufficient time within which to make these arguments. Now, if the judge grants it next week, then he grants it for everyone, right? If the lottery is delayed, that's good for everyone. That's why I said one option is to wait and see what the judge does. Having trouble hearing? No, I can't hear you, Mark.
Mark's on mute, but your mic is still a little bit choppy from time to time.
And we're now starting to get sound advice from the audience. So thank you, Brady. Thank you, Brad. It's good because we know a lot of the folks on the line right now are our friends. So it's kind of funny. This is when it makes me glad that we are the Medical Cannabis Network and not CNN. But we'll do the best we can.
Yeah, sorry about that. I don't know. I've never had a problem, so I don't know what it is.
It's good now.
Okay, and listen, if it's so bad, we can come back and record it and post it or whatever.
We're good. Keep going.
Okay. Anyway, that's where I left off. Where we left off was, if the judge grants the injunctive relief and delays the lottery process, it's good for everybody. And you don't necessarily have to have a lawsuit filed. Lawsuits can be expensive. So to the extent that you can, or just what the judge does in this case, you're probably better off from that perspective. You did hear, if you were on the call this morning, though, the concern raised by a plaintiff's lawyer about this 10-day period potentially lapsing past, that has some concern too, and certainly you never know what's going to happen in a case, well, right?
Let me interrupt you there for a sec. So this 10-day period lapsing, I just want to make sure I understand that correctly. The issue here is that for the purposes of the plaintiff's argument, the notice that they didn't win served as a deficiency notice. Is that correct?
That's right. For some. the ones that didn't receive a deficiency notice during the course of the grading process, or even on a particular exhibit where they were dinged points, the argument is, well, the first time that they realized it is at the notification last Thursday when they got that email.
So that's when essentially then, the legal argument goes, the 10 days would start for them to rectify that deficiency. Although they don't actually know what the actual deficiency is, they just would see this number or that number if they've even gotten their score.
That's right. And to be clear, I'm not suggesting that that's, I'm not advocating for that argument or suggesting that that's accurate. But I am saying that's another example of why you may want to either jump in now, file your own lawsuit. I mean, there's different options and different reasons to take one of these options. There are also other, let's not forget, there are other state court cases, at least one, I think multiple by the time we finish up today. I imagine there'll be others too filed. A judge in state court could enter a TRO even before next Thursday, and that happens. Now you've got a state court judge compelling or prohibiting the state from doing something that could be inconsistent, and so the best advice I can give just generally across the board is stay in touch. Listen to the people that know, or listen to what's going on with the different lawsuits, with the different options, and understand what your best approach is.
And, so I've just been listening to it and thinking through some of the language, and particularly that the defendants, the state used. And you know what, actually, let me say this. You're a lawyer, you're constrained by a number of things on what you can say. I slept at a Holiday Inn last night. That's my expertise in the law. So I'm going to feel welcome to make whatever editorial comment I want. And I want to be clear, that's my opinion. It's not yours. Probably wouldn't say, Abraham, it will likely reflect the opinion of the majority of our audience on the medical cannabis community. But let me say this. I was really offended. I've been really offended by sort of the language that the administration has been using. And I've been offended by the language that their lawyers have been using. J.B. Pritzker says, well, this is a marathon, not a sprint. Well, JB, some people have been running this marathon their entire lives. They're tired. They're sick of running. They want you to get it right the first time. Then there's this thing about, well, of course, that his advisor came out with, well, of course, there are going to be complaints with so many losers and all, with no acknowledgement that, hey, you screwed up. Own it. And today we hear in court this thing with what did the defendant's lead counsel say? He was sort of derisive. He called what the plaintiffs want a do-over. A mulligan, if you will. And no, what we want is for the state to have a do-right, not for us to have a do-over. Hey, Abraham, can we make that trend? Illinois do-right?
I think it'll stick pretty quickly.
That's what occurs to me is, hey, guy from AG's office, Deputy Attorney General, we're not asking for a do-over. Maybe you should do over your argument to the court and respect the people of Illinois who are paying your salary. There we go. Sorry, you guys. And I want to say that I'm a lobbyist. I don't generally bite the hand that feeds me. But in some ways, it's almost just starting to reek a little bit of sort of white privilege. And again, I don't need anybody to agree with me, but it's like, you people over there, we did it okay, you go away. That's the way it looks to me, and I just think it's devastating to the administration. But let's switch to actual fact, or at least non-offensive conjecture with you, David. So can you go through sort of the timeline of what happens next. There were sort of a number of dates. From what I understand, essentially there was no temporary restraining order, but the state essentially committed to the court that they won't do anything till the 23rd. Is that right?
Yes, we've heard that a number of times today.
Can we trust that?
I think when you say that in federal court and the judge says to you as a representative of the state, can I trust you on this? I think that's trustworthy.
Yeah, but is it trustworthy then when these individuals say we did a fine job, nothing to see here, Judge, or how does that work?
Well, right now, all the state is saying is that they're agreeing not to hold the lottery before September 23rd. That's it. In fact, I don't know if it was the judge or plaintiff's counsel who suggested this, but there might be a possibility that the state would agree to push back even further, and you hear their counsel say, I can't assure you of that today, but if we do get notice that we can push it back, we'll let you know, Judge. I wouldn't expect to hear that, but who knows? We'll see. Let's address the timeline though, because I think the judge is now assuming that, and we should all assume that the lottery will take place on September 23rd. And so the judge wants to make sure he hears this motion for emergency injunctive relief, the TRO, before then. And so he squeezed in a lot of stuff before next week, including, and again, let me know if you can't hear me, if I'm being choppy at all. Okay. So there's this issue of filing another complaint by adding in additional plaintiffs. Apparently the plaintiff's lawyer is going to do that today. I think they said by noon, with a number of other plaintiffs who are presumably similarly situated. He's not going to change any of the substantive arguments, but there will be additional plaintiffs named. They will also issue discovery to the state. Discovery is an opportunity for them to get information. And information will most certainly be extremely broad. Am I sounded off? Can you hear me, Abraham?
Yes.
Okay. So the discovery requests, the request that plaintiff's lawyer is going to be asking the state for is going to be very broad. They're going to want to know everything. You know, what was the rubric for KPMG's review of the applications? What were the communications between the state and KPMG? You know, and all the scores and all of the comments. So it's going to be very broad. You heard reference today from the plaintiff's lawyer. He even told me, I expect there to be objections to the scope of the discovery that we're seeking from the state. That will play out. So we don't know right now what the state's going to be asked for, but presumably it's going to be very broad, a lot of information. That'll play out tomorrow. I believe the judge is going to rule any objections to those requests on Tuesday. And the judge, you heard him make reference to referring that issue, that discovery scope issue, to a magistrate judge. So that's a different judge, Judge Gilbert, who's going to handle just the issues with respect to the discovery. You thought this couldn't get any more complicated, but it actually can and will. So there will be a separate judge that's going to rule on whether or not the plaintiffs are even entitled to all the documents that they're requesting. And the reason that plaintiffs are requesting the document, A, because we don't have them yet. There's a lot of information we don't have, but also because this will be an evidentiary hearing on Thursday. Evidentiary hearing means that you must stop now the sound issues.
Keep talking and move back.
All right. So on Thursday, it's going to be an evidentiary hearing, meaning the parties are going to present evidence, testimony from witnesses, documents that are going to be submitted into evidence. The defense lawyer, the state's lawyer said, we don't need an evidentiary hearing. You can rule just on briefs. The judge seems to want to hear evidence, which is good. So the judge will accept evidence next Thursday. But, this will what the judge hears is going to depend on the argument that's for sure going to come up with Judge Gilbert in terms of the discovery and the documents and the information that is being requested from the state, some of which we'll get, some they'll argue and object to. And then there's some briefing. The judge wanted to have a...
Why would the state object to releasing any documents? I mean, what would they release that would be object? I'm like this one. I'm not setting out. I'm really puzzled as to why the state would want to hold anything back.
Well, one reason is always in any situation is just strategically. Strategically, you'd rather give less for this is just an initial hearing, right? It's really important, but it's just initial. And regardless of what happens next Thursday, unless the judge dismisses the case outright, this case is still going to go on and still will be arguments made. So, strategically, I think the state wants to limit the scope of what's turned over. Sometimes it's in this situation, for sure, there's confidential issues. You heard there's reference made today about a confidentiality order that they want to enter protection of confidential information. So that can be an objection, but and essentially discovery should be very broad, should be. But the judge also said today he wants to make sure that the arguments are streamlined. And I think that what he's trying to do is avoid having 100 applicants personally come in or on Zoom and testify, and thousands of records turned over, and then ultimately maybe the plaintiff's lawyer saying, look, I got 10,000 documents. I certainly can't get through all these in the next 4 days. So we'll see how that plays out, but that's all going to happen very fast in the next few days.
So in terms of what happened, one of the things that sort of, actually first let me ask you, let me make two comments. This one's actually to Abraham. I've been getting a lot of requests for some kind of resource where all the denied applicants could sort of be in the same place, share resources, share information. I think we should, the medical cannabis. I love it when I say stuff to you like, hey, the medical cannabis community should do this. Make it happen. And you're the CEO. I'm me. In any case, I just think we actually should step up and create a resource for people where they can network. Because that's actually, it's interesting because that's been a theme for the last few people who've reached out to me. And then I saw Liz post something about saying, hey, if you have ideas or resources, share them in comments, and certainly do that here. But we ought to have something more organized. David, to you, I wanted to ask, short of, everybody separately calling you for a summary now that they know how great you are, is there in terms of educating ourselves, is there anywhere to track this other than like whatever the newspapers provide? And, or are we just going to build an audience base for Abraham for nothing by doing this? Yeah. So how does that work? Are there resources out there for normal people to tune in?
It's really, this is really messy because there isn't it's a great idea, Mark, and I encourage you to work on that. But there really isn't one place that you can go to learn about everything that's going on, at least with respect to the it's not blasted out anywhere when someone files a lawsuit necessarily. They are public record, so you can do your best to go on the circuit court website and see if cases have been filed. You can do your best to check in with folks like you and me who are keeping an eye on what's going on. There really isn't one specific place to go to get all of the information, unfortunately.
All right, well, so since you don't have enough to do these days,
yeah.
I was going to suggest that please keep us looped in, and whatever you share with us, we'll share with our community.
For sure. And this is a great idea. I mean, except for the fact that apparently the audio sucks, but, and I apologize for that on my end, but it's a great idea to hold these forums to update everybody out there. There's a lot of folks out there that are interested in what's going on, able to, for no fault of their own, just learn about, what's being argued, what's being decided, what's being settled. There's things that are happening, and it would be really great to have one place for everyone to go to if they want to hear about what's going on. So I think.
Ron, when we got the scores for a few days there, I think a lot of us are still sort of just in shock, David. I think shock is the right description that a lot of people have reflected to me. I think part of the shock is just the shock of not succeeding and seeing a lot of money go out the window. But part of the shock is just sort of the level of, I don't know. Look, to screw this up so badly, you either need to be incompetent or somehow malicious. And again, that's me, the non-lawyer, saying that. But as I said, I'm a lobbyist. I don't generally throw out accusations like that. But one of the things that I found interesting today was that John Lowy actually got to sort of make a speech.
He sure did.
And because that's why I almost said Perry Mason-like, because in real court, rarely do attorneys get to make speeches because either the judge jumps in or more often the opposition jumps in and says, I don't even know what the hell you're talking about, but we object. But here there was this speech. So things like KPMG's employee in Chicago being, which to me is still shocking because the medical cannabis community had screenshots of that employee's LinkedIn literally within like an hour or something, right? Within a few hours of the winners being posted. And it just so let me ask you this about that. The state, I don't think, has acknowledged at all, or KPMG, that this is any kind of a problem. They've just said, well, it was blind scoring. And I think that's inaccurate because if you're contacting people with deficiency notices, how's it blind? Do you know the emails that you're emailing to or don't you? So I don't understand how an entity can reach out to a particular applicant and ask them for information and then contend that that's a blind process. But, I'll leave it to legal geniuses like you to work that out. But in terms of this, so if the state or KPMG knew at some point in the process before the decisions were made that this was a clear issue of conflict, particularly since we're in the state of Illinois, and we've, just seem to have governors in jail a lot of the time, just saying. But they're telling us to trust them. And what's going on here?
So are you asking how that affects the lawsuit?
Yeah. I mean, if they knew before, yeah, sorry. You know what? I was so busy pontificating, I didn't even ask a question. But I guess the point is that if they knew ahead of time, apparently they found out when it was posted on the medical cannabis community, because that individual's LinkedIn profile was scrubbed of KPMG mentions within the next couple of days. But be that as it may, if they knew, would that have been, should that have been somewhere where they said, and stopped and said, wait a minute, we're not going to ask people to sue us for a do-over. We just need to give them a do right starting right now. And so, if they had known, would that have affected the process, and how?
Well, what I think you're asking is, are these issues that have been raised in the complaint, like the KPMG relationship and the others that are being alleged in the complaint that we've all heard about? How does that affect the process going forward in court? I think that's what you're asking.
Yeah, I mean, I guess does it really? Well, so no, I guess I'm asking several questions. First of all, to me, they're saying, well, we didn't know this, but even if we did, it shouldn't have mattered.
Well, let me say first, yeah, I'm not sure that we even know what the state's official position is on that. It really, these points have come out in the allegations in the complaint. We've seen them in some articles, probably just as a result of folks having read the complaint, read the allegations. As John said at the hearing today, he's getting calls with new information, on the hour. So there's a lot of this information that is slowly going to trickle out. I don't think, at this point, we really can't even be surprised anymore at some of the things we're hearing, but there's a lot out there. Now, the more evidence that there is that there were issues that weren't being attended to, right, that were improper, that add to the smell of what was going on with the scoring. And by the way, I'm not taking a position necessarily like you are, Mark, on any of these allegations. But the more that is out there, the harder it's going to be for the state to say that there was that this was a fair scoring contest. And so, those are all.
Does it matter that I think the judge was very surprised by how many people were listening in today? I thought that was interesting.
Well, I want to go back to something you said earlier about the judge allowing plaintiff's lawyer to give a speech. I felt that, and that does happen sometimes in courts. It's not, if I was
by the way, to be clear, I welcomed the speech and was applauding it on mute.
Right, and it was very it was well done. He got out a lot of information. And if I was the state's lawyer, I would have been objecting because I don't think it was the right time or place, except for the fact that what we know is the judge wants the information. The Judge Alonso would have cut him off.
I figure somebody in government actually wants to do something on the merits.
Well, listen, I think it was a good sign that the judge wanted the information, and he asked pretty good questions. In the sense that there were things that I think seemed basic to even John and probably a lot of folks on the call here with respect to the process, how many regions there are, how the lottery, I mean, I'm not sure any of us really know how the lottery is exactly going to take place. I thought that was kind of interesting how John's position was, look, there are going to be 75 lotteries. The state said, no, there's going to be 17 lotteries. It's probably just semantics, but most importantly, I thought it was important that the judge asked these questions and allowed plaintiff's counsel to, it wasn't just making a speech, but explain to him exactly what he's asking for. This is a big deal. TROs, immediate injunctive relief, is very hard to get in court. judges don't like to grant it.
Can you explain the 4-part standard or whatever that is real quick?
Yeah.
Of what
Sure.
TRO is based on?
Right. So a TRO, and this is why it's hard to achieve in court, because first of all, you're you're coming in basically and saying that you need emergency relief without, oftentimes it's without any evidence at all. Technically, a TRO doesn't have to have any evidence presented. In this case, it sounds like we are going to have some evidence presented. But the person seeking the immediate injunctive relief needs to show first and foremost that there's a right to the relief. You can get thrown out right away if you don't actually have a right. And I think the judge actually, he asked for a supplemental brief from the parties as to whether or not there is a real property right here. So I think he's got some concern there. You have to show that there's irreparable harm if the injunctive relief isn't immediately granted. So in this case, you know, is there irreparable harm if the lottery process goes forward without these other due process issues being addressed? If you also have to show that there's no adequate remedy at law, meaning essentially money damages. So this can't be rectified by just writing a check or settling for money. And then finally, you have to show, and I think the judge even alluded to this or stated this, a likelihood of success on the merits in the case. So at the end of this case, you've got a likelihood of succeeding. These are all really difficult standards. Sometimes some are harder than others.
Well, so let's say I didn't get social equity points. I clearly deserved social equity points. I submitted proof. I responded to a deficiency notice within 2 days with more proof. There's not ever anybody who questioned my proof.
Right.
I was scored to completion under the social equity application fee. Nobody ever came back to me and said, pay the other half because we don't think you're social equity. And you get your scoring back and there's not 0 points or 10 points, there's just an empty space, I think. So I mean, there's no way, there's no, you know, what can happen under those certain circumstances? You know what I mean?
Yeah, sure. And one of the arguments that is being made here, one of the primary due process arguments is that, to your point, Mark, there isn't an administrative remedy there. There isn't an ability for you to go to the IDFPR and say, wait a second, look at all this I have, and yet I got 0. There was obviously a mistake, right? And so this needs to be fixed before the lottery process takes place, because once the lottery process takes place, it's too late. That's the argument. And so otherwise you have,
you're right.
You have to go to circuit court and make your claim that there must have been a mistake because, look, you presented all this documentation, evidence, and you are a social equity applicant, clear as day. There must have been a mistake. By the time you get through that argument in circuit court, presumably the lottery process is gone and your conditional license is unavailable anyway. But so that's one of the due process arguments. It's a decent argument. Another part of the due process argument we've talked about is the deficiency notice, which also brings up the equal protection argument. Some people got deficiency notices, others didn't. Some people got deficiency notices in some regions and didn't in others. And some got dinged on sections where there wasn't a deficiency notice, when in fact the law states that there should have been if there were any deficiencies. So there's a lot there, but that doesn't change the point that this is still a very high standard. Very difficult for the plaintiff, any plaintiff, to prove enough, to establish enough of those 4, and they don't all have to be established together. It's basically a sliding scale, but very difficult to actually get a judge to enter that.
So Again, you talked about you can wait and see what happens in the next few days. I've also got the question now of, we listened in on the hearing. How do we contact these guys? Or what, is there some actual process that goes along with adding your name, or are you just calling the Lowy law firm and saying, hook me up?
Yeah, you would, I would send an email and call up as soon as you can. It's possible.
Do we know send an email to whom? I don't know John's email address.
Yeah, it's Google.
Actually, Brad Zerman just popped in with John Lowy's email address on comment. So anybody who wanted to know how to reach out to John Lowy, i.e. the Illinois Cannabis Perry Mason, now you know where to get him.
Right, and reach
out. I can't decide Perry Mason or Robin Hood. What does he look like? Because I've never met the guy.
No comment, Mark.
Okay. Sorry. I do have to add some entertainment value to these things.
Doesn't matter what he looks like. It matters how he presents his argument and how he proceeds and whether or not he gets this injunction. That's what matters.
So I'm also sensitive to pronouncing last names right, because apparently I've been saying Lowy when I should have been saying Lowy, or what's the actual last name? Because Brad Zerman's correcting me, and given that I'm a Pasakovich, that matters to me.
Yeah, you have a lot of experience with difficult to pronounce names.
How do you pronounce his name?
Lowy.
Lowy.
Yeah, unless you're from a different part of Europe, and then I guess it's Lowy.
Okay.
I don't know. We digress there, but
yeah, we'll have to delve into his ancestry at a different time.
But definitely get in touch with him. And one of my concerns is that, and this is just general, is that he might not be in a position to immediately take on new plaintiffs. You heard the judge today say he asked the judge for additional time, I believe till Monday, to add in additional plaintiffs, and the judge essentially denied it, and he said you have until noon today. So,
if you reach out to him and you don't hear back, what do? Do you reach out to you?
Sure. I mean, that's fine. Reach out to a lawyer. It doesn't have to be me. It can be any lawyer who can help you get into contact with John at some point over the weekend. Look, they're not getting any rest for the next week on this case, right? There's a lot to do. And
they told the judge they could do it.
Right. So it will be possible to get in touch with them. And actually there's other people over there in addition to John and Mike who people can get in contact with.
Okay. So maybe, I guess maybe the advice is that if you had a lawyer you like and trust who's taken you through this application process so far, you probably start talking with them rather than just calling John.
No, I would listen. There's no problem with reaching out to John as soon as possible. If that's
that's not even what I mean. I guess what I'm saying is that are you best off having your lawyer to talk to John, or do you want to reach out to John directly?
No, the sooner the better. If you're going to contact plaintiff's counsel, you should contact him as soon as possible. Don't wait to have another lawyer reach out to him or her. But if you have trouble getting in touch with him, definitely reach out, to your lawyer to try to get that to happen.
Abraham and Shawnee, I think we've had like the internet work, I guess the chat part of this has been exploding. Do we have a lot of questions, and we have, still a bunch of people watching. We should get some of their questions answered. You guys want to jump in with questions?
We've got a good one from Mitchell Anderson, who asked, would a favorable ruling on selected plaintiffs potentially trigger the equivalent of a class action lawsuit where all scores would be reviewed?
First of all, hi, Mitch. Thanks for the question. No, there's some, there's some different concepts being discussed there. So it doesn't trigger a class action. In fact, arguably, this isn't really ripe for a class action because we know, to get into the details of the class action standards, but we know everybody, we know the applicants know who they are. It's a set group. And so it doesn't trigger. If there's a ruling, I think the question was if there's a ruling in favor of, in this particular case, the ruling should be initially, and we're talking about, so next week, it sounds like, a stay of the lottery process. The plaintiffs are also asking for, though, a review of some sort, and we're not really sure what that's going to look like or what even they're going to necessarily ask for, but a review of the deficient aspects of the application wherein they didn't receive deficiency notices or there were inconsistencies in the issuance of deficiency notices. And in that event, I'm not really sure today what the judge is going to rule, although I think it would be difficult based on that ruling to say only these folks can be reviewed and not anybody else. And certainly that ruling would have ramifications across the entire set of applicants who find themselves in that position of having an exhibit where they got less points but no deficiency notice or inconsistent scores. And if they found themselves in that position, they would be arguably entitled to the same ruling that the judge gives for these particular plaintiffs. But one thing that could happen, let me just throw in there, it's possible the judge could limit what the state has to do in terms of this review or next steps. And so we'll know more. We won't know now until the hearing, but once the judge rules, if he does stay the lottery process, then it'll be interesting to see what he does in terms of what the state needs to do from there on out. And you may have to, people on the call who aren't plaintiffs in the case may have to file their own lawsuit.
Because our friend Brad Zerman in chats like, hey, email him by noon, or you turn into a pumpkin.
Yeah.
Do you get another shot? Can you, are you just gonna? Is it another shock this weekend if you miss this boat as well after being screwed last week by the state? What's that gonna? What happens?
The general rule is you have the opportunity to amend a complaint really at any time throughout the entire process, as long as it's the court gives you leave and it has, you're not surprising the other side, et cetera. Adding in plaintiffs, I think the judge wanted to limit the amount of evidence that he's going to have to deal with at this hearing next week. So he wanted to, and you even heard him, to the extent, counsel, you can streamline this process for me, please do so. Those are things that litigators pick up on. You want to be on the good side of the judge, or I should say, you don't want to be on the judge's bad side. So they will streamline as much as possible. John, I suspect if there's enough folks that want to get in after 12 today, he may make another attempt at trying to ask the court for leave to add in additional plaintiffs. It really shouldn't matter in the long run. Again, I said earlier, if the injunction is granted on Thursday, it's good for everybody. If it's not, it's not. And ultimately,
and then you sue.
Yeah, yes, you can, but it will depend on how the judge rules and what he says. And again, I'm going to go back to the fact there are other cases in other courts that are popping up.
So if somebody wants to sue now, should they sort of do it like they did with applications, submit them everywhere they can, as many as they can? That is to say, what's the difference in terms of venues, state court, county court, federal court, where do you want to file the lawsuit and why?
Yeah. So again, I said earlier, I'm not giving any specific advice.
No, absolutely. No.
But there are differences in the courts. There are differences in the judges that sit in those courts. You get randomly assigned. So you don't really know. It's not like you can judge shop. And there are differences that people feel about the federal court versus state court. If you're in state court, though, you will need to be either in the Cook County, Circuit Court of Cook County, the Daly Center, or the Circuit Court of Sangamon County, which is Springfield, one of the two, or federal court.
All right. Edie Moore, the executive director of Chicago Normal, who, by the way, came out with a recent position statement on what they would like to see happen at this point. And I'd encourage everybody to check it out on their website. But Edie had, and I guess David, Edie had a question more about the legislative stuff. I think I'd probably be able to answer that question better than you would. And I guess what I'll say, what I know is that, what I've seen, what I've been engaged with is that Representative LaShawn Ford and State Representative and Leader Kathleen Willis have sort of teamed up on putting together some ideas on a shell bill or on a trailer bill. I think they're reaching out to their colleagues to see how they might all work together to see if other bills will be resurrected. It's generally not. Usually, if a bill hadn't passed, it'll probably be rewritten or refiled with some tweaks rather than necessarily the old bill being voted on. But I would hope some of these concepts would be brought forward, and hopefully we need to make whole some of these people in the legislative process, but we're not giving up our right in judicial review, right? That is to say, you can't legislate competence in the state scoring process.
That's correct. You can't legislate competence.
Thank you. I feel vindicated. Abraham, do you want to go to more questions, or Shawnee?
But I will say, Mark, to that point, there should be an expectation of competence, right? So to that end, it does end up in court in a different.
Let me tell you about my mental calluses sometimes. Although one of my favorite mottos in terms of working with government is that generally they're not out to get you. I have to remind myself of that. And so, like, even with the state process, I think they just forgot to go in and add the points after they got the deficiency responses back. That, again, huge speculation. You don't even have to nod your head to it. Right. But I guess the bottom line to me is that I often, because people are like, they're crooks. And I said, well, this definitely stinks, but I don't think they could have screwed this up on purpose so bad. And so to me, it's always sort of it's sort of, I guess I always say to myself in dealing with government, don't attribute to malice that which can be explained by stupidity. That has kept me sane as a lobbyist for a long time, because you get paranoid. Although now, with everything I've been spouting, there may definitely be some malice when I go back to Springfield. But you know what? I'm doing the best I can for the people that I work with and represent. Hopefully, that means I'm almost like a lawyer. I'm sort of immune from, if I insult you as a part of my job in court, then I'm immune from you being affected. So,
and I will say too, Mark, to that point, things happen during the course of litigation that influence results, right? There doesn't have to be a decision by the judge on Thursday for the state to take some action. Or the judge could enter an injunction on Thursday, which then could cause, more discussions to happen or the legislature to act. So, keep an eye. This is one
Can
of the
the
things. to keep an eye on.
legislature possibly act on the actual licenses on the table now? Or is that now an administrative and judicial matter? The legislature can't go back to Springfield and say, all right, well, we're going to pass a law that scrubs everything and is going to be, we're not going to hand out any licenses to anybody. Or they're going to go to, Springfield and say, we're going to give, one license to the 75 highest scoring applicants or whatever. Can the legislature do that retroactively, or is that sort of an unconstitutional infringement on the rights of the people who won?
Yeah, so it depends, of course. But I would say, generally speaking, no, not retroactively, but certainly there are options for the state to step in, call it settlement discussions if you want, whatever it is. There is litigation pending that has certain requests for relief, and for the state to, if they dig in their heels and say, look, let the judge force us or compel us or prohibit us, fine. But I think, as what I said earlier, during the course of cases, things change, information comes out. Or maybe judges will make comments here and there, right? I mean, the issues that are not going to come out in this particular case that we heard today over the next week, I mean, we're going to probably hear things daily, information that's coming out through the discovery, how the magistrate judge rules on the scope of discovery, what he allows, what our judge thinks about, potentially even before Thursday, the supplemental brief on the property rights. There's a lot of things that could happen, and hopefully John and the state are talking during the course of time. And so, would it take a legislative act to do that?
Is there any indication of that? I mean, how does anybody know? Or is that not something you know until you know?
It's not something we know until we find out. John today said at some point, or maybe it was in their joint status report, that, by the way, I love the fact it's a joint status report. I thought that was really funny.
I didn't even think of that. I'm usually the corny guy.
So you can use that. But there was reference to the fact that they did sit down and talk. I think it was yesterday. He didn't specifically say who was doing the talking or listening. But there absolutely is communication. There has to be in a case like this with such big implications. And we'll see. Every day is going to bring something new.
Right. So another really important topic of conversation that's emerged is the subsequent licenses coming up. But in particular, the licenses that are now, pending to be, from what I understand, again, nothing you need to comment on unless you can, confirm information. But from what I understand, the scoring of the craft grow, transport and infusion licenses has been completed and is sitting there waiting to be released. And so, I don't know if that's true, but I would assume so. So the question is, do we trust those people? Should we be demanding that the process be stopped now because they screwed it up? Now, before I let you answer that question, I'll answer it myself, with my opinion. And to be very clear, I have an axe to grind. I have clients who I helped with craft grow applications. And so this is not just, I love everybody decision. This is a business decision, and I'm supporting my clients. In this particular case, the question is, do we demand that it stops now and that the state potentially take another look and go back and fix it? My sense is absolutely not. I don't want them scurrying back and doing anything. I don't want them reopening anything. I think they had their chance. I think that the rest should be put out into the sunlight immediately. We are stupid to be opening up and licensing dispensaries that are not going to have anything to sell anyway. because the craft grows haven't been online yet. And so I think for the patients of Illinois, for the consumers of Illinois who want more variety, better products, lower prices, we need to get those craft grows out as soon as possible. And I think the best way to do that is to get it out of the state's hands immediately, all in the public domain, and figure out what we do from there. I don't think we benefit by demanding that the state slow down the process of craft grows, because I don't trust them to have that stuff sitting over there. You know, when are we going to find out somebody else at KPMG tweaked something?
Right.
You know, again, so my personal opinion, my personal suspicion, having done this before, is that you don't sort of ask the guy who robbed your house to go back and put it back tomorrow. So does it make sense to pause this, or should we be moving full speed ahead? And again, Howard's saying, I think Edie Moore is saying, a lot of other people are saying, the state, you know, this is like malpractice. And again, I slept at a Holiday Inn last night, so I don't know what that would even mean, legally speaking. But the point is, Edie's saying the state should refund or KPMG should refund application fees. And I strongly believe that. In fact, if I was the state, I'd say, KPMG, unless you give us all our money back, you're never getting another contract. But that's my, you know, again, that just is the outrage of a, you know, loudmouth taxpayer, not necessarily a strategist. But I'll take a breath now. What do you think about craft grow?
Well, I thought, first of all, I mean, what happens in this round of litigation is certainly going to have an effect on the craft grow, infuser, importer, transporter applications, of course. Even if they've already been scored. I mean, we're learning things now about the scoring process, which, I mean, with the lack of transparency, we don't even know what KPMG's directive was. We don't know how they're scoring. We don't know if they're scoring the second round, the craft grow applications, the same as they scored the dispensary applications or not. We don't know. We really, the lack of transparency is the same. And so that's why I'm not sure, Mark, you said you would want it all to come out. I think that we're better off, let's gather as much information right now as we can through the litigation that's pending with respect to the dispensary issues that we're having now. And hold off. Look, I don't want to delay anymore. We've had enough delays, and I know all the issues with the delays, and it's horrific. But at the same time, what's the point of announcing, winners, if you will, when we're arguing that the scoring process was unfair and flawed to begin with?
So I mean, I guess, well, again, my perspective on that is, yeah, we're having litigation about these licenses. What's the solution for craft grow, right? I mean, we're getting information. We might be learning stuff. What we aren't doing is growing product, getting customers what they deserve in the state in terms of product and pricing and all that. I mean, hell, if the product is so expensive, then maybe we should lower taxes to make consumers whole. But the point is that what I'm not understanding is that when we say, all right, well, let's pause this, let's not do anything, then what's the ultimate outcome there? I mean, that process, because we're not saying here's what we're going to do, pause it for what?
Well, we don't know yet, right? We don't know yet, and we don't even know.
Well, lawyers don't know yet. Us people who've made up our mind, judge, jury, and executioner, we've already convicted. No, but I'm just kidding. But go ahead,
I understand your frustration and the frustration in general. And let me take a step back and just say the hope is that whatever results from the litigation that's going to be out there from this first round, we learn, the legislature learns, the governor learns, the participants all learn that a competitive process is really difficult, right? There's never a win-win in the states with competitive processes. I look at all the litigation around the country, in the different states. So what's the best case scenario here? It's probably not a win-win in this first round, but how about if we learn it and we change it so that in the next round, one of the few good things that I think is a result of the limitations on the licenses. And when I say limitations, meaning, it's 75 dispensary right now, up to 500 over the course of the next couple of years. But one of the few good things about being so limited is that we can actually learn from this process and make it better.
Yeah,
Is it going to be?
What I'm afraid of, and what's interesting to me is that there's a lot of talk about, well, what do we do next time to fix what we did this time, right? So we can't give them this, but we're going to give them that, and that's fine. Anybody who has anything coming, I think they should get it. But this is the history of the way these things work. If you're going to start handing out goodies to make people happy, what you're essentially doing is watering down the value of every license. So you're going to give licenses to people you think deserve licenses. And every time you give out more licenses to people who deserve licenses, got screwed. You're diminishing the value of the license of every person that you helped the month before trying to fix the thing that you did wrong. And so, again, I'll argue with you all day long, but I am not at all at this point interested about learning. And what we're, again, in private, I'm working with legislators who have reached out to me, who have reached out to the medical cannabis community because they like the idea of working with an army around.
Good.
But the point is that to me, and again, you got me, I'm quoting my favorite person, myself. It's like, this is unconscionable. Do right. Do right, not next time. What bothers me is that JB Prisker's treating this like a downtown incubator. He's iterating. He's going to do this, then he's going to tweak that, then he's going to tweak it some more. And lo and behold, in 5 years, it might be a perfect tech company that can go public. Well, that's great, but this doesn't work that way. And I guess my point is that nothing we do next year is going to make whole any of my clients. I would assume none of your clients either. Well, you know what? I'm getting too heated, but talk to me.
Listen, there's litigation that's pending right now. It can't address specifically the next round, and it can't really address what happens even next year for the next round of dispensary applications. But what we hear come out of the courts should, unless there's some resolution without an actual decision, what we hear come from the courts should affect what happens here on out. And that could be enough to affect the scoring of the craft grow applications, whether or not they're completed or not. The decision that, whether it's this Judge Alonso or a judge in another case, renders could have an effect on that round of scoring, even if they're already scored.
Now, if they're scored and they're sitting at the governor's office and he's just sitting on them, and he sat on these dispensary applications for a couple of weeks, ultimately, unfortunately, they didn't use that time to make some of the right decisions. At least one would hope they could have said for a couple of weeks, you know what, let's bring a couple of, Bob and Joe are going to need to work overtime because we need to provide full disclosure to all these applicants who are calling us for information. They couldn't even do that. Okay. So given that, if that if the KPMG is officially done doing its work and has transmitted those results to the state of Illinois, and the state of Illinois is now going, oh shit, maybe we should at least go back and not have the points, single point here and there taken out so randomly. Oh shit, if there were similar applications that were submitted, let us go back and make sure that everyone has the same score, because this makes us look like morons when the same application receives 3 different scores 3 different times from the same scoring entity that had paid millions of dollars to score these things right, but unfortunately does not have an internal employee conflict of interest policy, because they certainly won't release one, so I assume they don't have one. And again, you use a conflict policy to protect yourself from conflict. So that would make me think that would be the first thing you would do, is say, we have a strong conflict of interest policy. Here's what happened. That has not happened. We've just gotten these, hey, it was blind. Take our word for it. We're KPMG. So how did you know who to email when you wanted deficiency information? So I guess, you know what, I don't even know what the hell my point is anymore. Like, you're starting to look like J.B. Pritzker to me, which is why I'm going on. And, you know, it's funny because we still have an audience, so they must like it. But, you know, again, my point is we seem to be maintaining a lot of faith in somebody to do something right and learn something and fix something before they go too far, even though they did nothing in the first place. But you know, that said, are they the right people to go back and fix whatever it is they have now? Do you trust them to do it? Or do you want to see what they've done and go from there?
Honestly, Mark, at this point, I don't really even want to, I don't want to go that far down, you know.
And you don't have to.
I don't know at this point. And, you know, I'm focused more on the legal rights and what rights do we have. You know, I thought maybe where you were going to go is, as a craft grow applicant sitting now listening to everything that's going on, what rights do I have to maybe—
Please, because that's actually more useful than the bullshit I was spewing. So let's go right there.
No, listen, it's I can't get away from the legal focus and analysis, and I appreciate everything that you're saying, and I get it. Right now, without a score as a craft grow applicant, you really don't have standing to make a claim that anything was improperly, you know, any violation of due process or equal protection like that's being claimed right now. The issue that has come up though, repeatedly, the question I get asked a lot is, well, what about the fact that in the craft grow application, I had to obtain a property, and I'm holding property at a tremendous cost that I didn't have to do for the dispensaries. So what about that? And isn't there some ability to challenge the delays? And now, you know, what we're hearing with all the allegations of scoring flaws in the dispensaries, is this going to delay me even further? And am I going to be out more money? And how long do I have to hold this property, et cetera? So those are, you know, that issue with the property, to me, is a better focus for anybody who's seeking to get some relief. But the scoring issues and the due process issues don't have.
Let me just interrupt again. Just give me specific, for example. So the scoring is done. It's sitting at the governor's office. At this point, I'm not making that statement. I'm saying hypothetically, the scoring is done, it's sitting at the governor's office of state X. Okay, not even this state. The scoring is done, it's sitting at the governor's office. We are at this situation where I think, there's screw up of historic proportions. So you could say that, the governor would say, well, let's take another look at these and make it right. Okay, that's a very reasonable thing to say. Another perspective that I've heard is, hey, let's scurry back and cover our trail and do a better job of whatever it is we were doing, not do it right, but make ourselves look better. So if you're a lawyer and you have a client who's affected by this process, what are you going to say to the judge? The state should have gone and corrected this? Or are you going to say, well, the scoring was done and they didn't, they should have just released it?
Yeah, we'll see how it plays out. I would hope that seeing what the state is seeing right now, the allegations, they're just allegations right now, but we know there are some concrete examples of inconsistencies and issues, right? So seeing that, I would hope that somebody at the IDFPR or the state level is taking steps to address those potential issues on the next round. I don't know if that's happening. I don't know if it's going to happen. I don't know what, when we get to that point, whether the scores are going to be released, whether the decision in this case, as I said, is going to have an effect on the next round. So, and maybe not even this case, maybe another, one of the cases in circuit court. So time will tell. It's impossible to answer at this point.
Yeah. And again, I view it as somebody who's worked with applicants, and I view it as a consumer. And as far as I'm concerned, in both instances, we benefit from the state getting this out of the state's hands as quickly as possible. And if I, for one, this guy today that represented the state was speaking very derisively of these applicants wanting a do-over. Well, should we be giving the state a do-over, or do we want them to put their cards on the table and move it from there and actually try to, fix things that should be fixed for the next round, which doesn't matter this. But you know what? If we didn't disagree, it wouldn't be exciting. And I think we're part of the same thing. I think the fact is that loudmouth people like me whacking away publicly probably helps the lawyers on the back end. So, if I have to be the class clown, so be it on behalf of my clients. Abraham, did you want to, I could talk for another 3 hours. We've already been at it for 90 minutes. David's very patient. He's probably going to stop taking calls from me altogether from now on.
But I am billing you though, Mark, so you'll get an invoice.
Oh shit, we're done. In any case, Abraham, what do you want to do? You're the boss, and Shawnee actually is the boss as well.
It looks like we have a couple more questions. So if we want to open it up to a quick Q&A for 5 or 10 minutes, I think that it'll be a good idea to get everybody's responses in there before we start wrapping up.
And here's what I'm going to try to do. You guys can see me. I might have to sign some kind of an agreement with David to make sure I keep to this, but I'm actually going to mute myself and try to stay quiet for the entirety of the Q&A.
One of the questions that was asked by Walter Williams was if Ruskin could elaborate on how craft grow might potentially be affected as a result of this process.
Yeah, great question, Walter. And I'll elaborate on it by saying we don't know. Unfortunately, it's like one of the number one questions that I'm hearing and that I'm sure you're all asking. How is it going to affect? So certainly if, as I said earlier, if there are issues that the state is seeing in the scoring process, and yes, we've seen some already. You would hope, I would hope, I think we would all hope that those issues would at least try to be addressed in that round as well, assuming that the scoring is, KPMG has been directed to score in the same fashion, which I think we can safely assume they have. Really isn't all that different other than, you know, some of the different exhibits and focus of the exhibits. But presumably, as information comes out in court, and the state is learning, you know, you and I may not necessarily learn everything that the parties learn through their discovery process, but the state certainly knows, and the state is learning. And in the case that we were talking about from federal court today, they're going to be asking for a lot of documentation and a lot of information. And so even if the state and its lawyers didn't already know about this, they're going to learn about it over the course of the next several days or so. Again, I would hope that if there are real issues that the craft grow and the infuser applications also get reviewed sooner rather than later, so that we don't have to go through this process or the same process again. It might be a different process, litigation I'm talking about. But other than that, there is no claim right now with respect to the craft grow and infuser and transporter applications in circuit court or federal court. So, you know, the direct answer to your question is there won't be any direct order from the court with respect to those applications. It's not in front of the court. The court really doesn't have the ability, I shouldn't say the ability, but certainly it's not before the court right now. So could it be in the future? Could it be, depending on what comes out through the discovery and the evidentiary hearing next week? Sure, it's possible. I said earlier, I think it's very likely that what happens in this round of litigation is going to affect the craft goes. I just don't know how. Does that mean it's a delay because the state needs to review them more? Maybe. Is it a change in the...
And we're okay with that?
I'm sorry, are you asking if we should be okay with that? Or
Yeah, as a representative of clients, and I guess I failed, I unmuted myself, but as a representative of clients in this process, do you have confidence that the state is gonna do the right things from here on in? And if not, then should we give them the chance to mess it up more?
So I'm gonna, I'm gonna ride the fence a little bit and suggest that I'm not sure if it's, this flaw, there's alleged flaws here on the state's part and on KPMG's part. There's a flaw in the scoring process, which comes from the law itself. And so, but again, we don't know what KPMG was instructed to do with the scoring or how they were instructed to score. Maybe they went rogue, or maybe, somebody who was scoring. One thing I think we do know is that there were different reviewers scoring different exhibits in different regions and different applications. So, there's a lack of...
Or there were the same scorers who said, you can't give everyone a perfect score, just go through and take a point off here and there. I'd say that perspective is at least as valid as any other.
So to answer your question, I don't, at this point, trusting the state, yeah, I still hope that the state is going to do the right thing, learning what they learn every day, that we learn more information about, things that are coming out about the scoring process and the challenges that we're facing. And do I trust that the right thing is going to happen? I don't know. At this point, I don't know. And I care, of course, but my focus is helping people that have issues. And from a legal perspective, what are their rights? Where have their rights been infringed? And are there ways for them to be made whole, or at least partially?
Well, you're more more honest than most of the legal analysts I've seen on major networks. Just refusing my efforts to scandalize any of this in a tantalizing way. But I mean, you're right, of course, and there's a lot. Abraham, sorry. Go ahead with more questions.
Actionable insights before we all leave in and wrap up. What are the top things that people should do as soon as they get off this call?
And should they find you on LinkedIn, email you, give us some direction on where to find you?
Yeah. So, and you know this, Mark, because I say it all the time. I'm happy to talk with anybody who has a question about any of this. And it doesn't mean that that's going to result in you filing a lawsuit or you even being, retaining me as your counsel. You can certainly speak with, there's a lot of good lawyers in this state. So, but I do recommend talking with and staying in touch with people who know and are paying attention to what's going on. If you think you have a claim or that there's something that was wrong that you want to have addressed or you have questions, certainly feel free to reach out to me or plaintiff's counsel in this case. I may even direct you to other lawyers that are handling some lawsuits, because there are other lawsuits filed. And so just get your initial questions answered, and then you can make the determination what's the best next step for you, right? For what you have going on. There are different people decide to sue or not to sue for many different reasons. And you have your own reasons. So it's to me, it's fine figuring out from a lawyer what your options are based on your specific issues, and then deciding from there what to do. And, to the extent you decide you don't want to reach out to a lawyer, or you definitely don't want to file a suit, but you just want to see what's happening and you want to know what's happening, stay in touch. And I don't know, if Abraham, it's fair for me to say, you'll be updating on Medical Cannabis website, everything that happens here. So that's one place you can stay in touch. Mark will probably be posting things on LinkedIn. I don't think a day goes by where he doesn't. So, that's another place.
You say it like it's a bad thing.
Not at all. Not at all. It's where I get most of my information from. So, that's my advice right now. Stay in touch. A lot is going to happen in the next day to 5-6 days, and we'll know a lot more. And maybe we'll come back on and do another presentation with better audio.
There towards the end, just like the state, it had an opportunity to correct itself. Unlike the state, it took that opportunity. Last question, but in terms of actually reaching out to you, you want to give out an email address, or do you want people to reach you via LinkedIn message, or what?
And can you drop the email address in a chat or something? I mean, that's fine. I think my link was on the invite.
Well, just say it out loud anyway. What's your email?
It's D Ruskin. You can see my name there. DRUSKIN at HMBlaw.com. HMB Law.
David, thank you very much. I mean, I definitely couldn't afford it an hour and a half with you if I was paying for it. So I feel, but realistically, the fact is that there were a lot of people on here who don't have the luxury of a high-priced lawyer, and you're doing the Lord's work. And I think all of us appreciate that. And we'll definitely try to get you back on.
Last question that I have before we wrap up. Naturally, a lot of trust has been lost in this process with the state and KPMG. A lot of people are wondering how the KPMG organization was able to receive a no-bid contract over the value of $7 million. What is the process to potentially open up a new contract for another organization who could provide a third-party independent review separate to the state and KPMG?
That's probably more a Mark question in terms of the process. The judge, depending on what comes out, a judge in one of these cases could order a review of the scoring process. That is a huge undertaking, but it is certainly on the list of things that judges can do. So that is possible. And I think it depends a lot on what type of evidence we see come out, certainly in this federal case that's in federal court right now, the evidence that we see come out, if there's, boy, if there's like real obvious major issues within the KPMG scoring process, it's certainly possible the judge could order a complete review of the entire thing. I mean, we'll see. But and in terms of how to get a third, from another perspective, not the judge, Mark, you'd know better from that perspective.
Well, so first of all, I just wanted to note, and again, I didn't read it myself, but somebody was actually looking at it, said they were doing some day trading and went onto the website of the Federal Reserve and realized that KPMG edited audited the Federal Reserve. Wow. I wonder if they have any people, spouses of Federal Reserve employees working at KPMG. Maybe they should check it out. But in any case, I will say this, and I'm not faulting legislators on this or the state. I've been very critical of the state. The state didn't do anything wrong in letting a contract quickly. All of us were sitting there going, we want this done quickly. We want this done quickly. We want this done quickly. Roll this out. And, again, to me, the bottom line issue is that I'm a consumer and I have a lot of friends who are patients. And I am for consumers and patients, and doing it quickly is pro-consumer and pro-patient unless you're dealing with incompetence. And so what the legislators and what the lobbyists and all of us who were, sort of the interest groups did, say, well, look, in this particular legislation, it might be worth saying the state doesn't have to follow really, really bureaucratic, really long, really complicated state contracting rules, because there's going to be some special competency, okay? It's not like anybody can do this. One would think there would be some particular reasons that somebody would, I'm going to hire David to deal with my cannabis stuff. I'm not going to hire, a divorce attorney. And so, the sense was that if the state needed the flexibility to find exactly the right entity to do this and to engage it very quickly, that's the right thing to do for patients and consumers. And I commend the legislature for doing that. And so that said, right, I don't think anybody felt they had to say to the legislature, to the administration, well, you know what? Before you give this contract out to like a major international conglomerate, could we find a Illinois-based minority consulting group that could do this? I don't know if we could find them or not. Love to have the question answered. And then subsequently, perhaps even the more important question, although I'm all for that first question, the more important question is, why did we hire them? Why, and was it because they said they were going to hire experts in cannabis dispensary operations? We don't know. So look, it's just yet another time that we had very good intentions, saying, you know what, Governor J.B. Pritzker and your team, we really trust you to do the right thing. And, you're a businessman, got billions of dollars. You probably deal with all these consulting firms every other day, know their CEOs. We trust you to do this right. Here we are. So again, I gotta go take some blood pressure medication, I think, or something.
Yeah.
Excellent. Well, it looks like we're all out of questions for today. I imagine that we're going to have many more to follow up on as people track and trace what is happening in Illinois as it relates to social equity. So I appreciate all of you making the time to join us today and in future events going forward. Be sure to check out our website at themedicalcannabiscommunity.org, our Facebook page at The Medical Cannabis Community, as well as our groups. If you're not a part of them, make sure that you join so that you could keep up with all of these events in real time. And be sure to subscribe to our newsletter so that you could get these updates conveniently in your inbox. With that said, I appreciate all of you taking the time to join us today, and I hope you enjoy the rest of your weekend.
Thanks, Abraham. Thanks, Mark.
See you, David. See you, Mark. See you, everybody.
Thanks, everybody. Hang in there.